but that's not what it's about. Nobody is disputing that Judge Lee is a fine judge. Nobody is disputing that the concept of the care court is a great concept. Nevada law has always provided for an elected judiciary. Every effort to do away with an elected judiciary has been struck down by the electors. The argument is you're violating Nevada public policy and law in appointing a judge for a period of 6 years. Nothing in Nevada law provides for that kind of an appointment. We have an elected judiciary. The electors have the right to vote. That's the problem.
ACLU of Nevada on behalf of Petitioners.
Good morning, Your Honor. Pat Lundvall from Romero here on behalf of the City of North Las Vegas. With me here today is my colleague, Daniel Aquino from our firm, and also representative of the city, Marissa.
Okay, thanks very much.
And Your Honor, I also have Chris Peterson with me at bar number
1392.
Thank you, Mr. Peterson. All right, so this is the ACLU's petition for writ of mandamus. With respect to judicial elections in the city of North Las Vegas, specifically for Department 1, which was filled by appointment about a year ago. Mr. Romero, if you want to proceed.
Thank you, Your Honor. The matter before the court today is one of plain statutory interpretation. The only issue here is whether the charter which governs the city of North Las Vegas allows its mayor and city council to appoint a municipal court judge to a 6-year term. The clear answer is no. The charter requires that when there is an appointment to what would normally be an elected position, that position must be up for election at the earliest election following the appointment. The city of North Las Vegas knows this, which is why when Department 2 was created in December of 2004, an interim judge was appointed in January of 2005, a subsequent election was held, and a successor was elected in June of 2005. Now the city is attempting to convolute the issues at hand and muddy the record by adding language to the charter which simply doesn't exist. Additionally, the city cites two numerous irrelevant and often inaccurate facts as well as ancillary statutes which are inapplicable because they are inconsistent with the language of the charter. However, in the answer itself, the city admits that this dispute is a pure question of law regarding the interpretation of the city's charter. The language of the charter, which is the embodiment of the legislative intent in this matter, is clear and specifically states that the charter itself controls. When reading the charter as a whole, which statutory interpretation requires us to do, it is clear that the language of the charter spells out the process for appointments and limits the terms of those appointments. Additionally, the statutory scheme of the charter is simple and clearly favors elections. The applicable sections of the charter are 1.050, 1.060, and 4.005. Section 1.050 names the elective offices, recognizes there may be more than one municipal judge pursuant to section 4.005, and in subsection 2 states such officers must be elected as provided by this by this charter. Section 1.006 talks about vacancies and gives the method and rules for appointment. Again, here subsection 2 states no such appointment extends beyond the first day of the month following the next general municipal election. The procedural framework for appointments from subsection 1 is what was used to appoint the current judge in this matter. The city would have the court believe that this statute somehow only applies to midterm vacancies, but there is no such limiting language in the statute itself. Section 4.005 then specifically discusses municipal courts. Section 1 covers the duties of municipal court judges. Subsection 2 gives the city council authority to create an additional department and appoint a judge to fill that vacancy. Just to be clear, Your Honor, we are not arguing that they do not have the authority to create a new judicial department.
It's not really a new department.
Excuse me?
So it's not a new department.
In their ordinance,
Department 1 kind of begs the question. If you have Department 1 and Department 2, is it Department 1 existing?
Your Honor, I fully agree with you that it's not a new department.
It was just vacant.
It was a vacancy that they filled. And it is not a new department. But, Your Honor, according to the ordinance 3060, they're calling it a new department.
They can call it anything they want.
They can call it anything they want. But, and then, of course, under 4.005 subsection 5, departments have to be numbered numerically, starting with 1. So, just by logic, Department 1 is the oldest department in the city of North Las Vegas. I 100% agree with you, Your Honor.
Right.
However, under 4.005 subsection 3, at the first primary or general, even if it was the new department, 4.005 subsection 3 says that the first primary general municipal election that follows the appointment of an additional, and it says appointment, not the term of appointment, of an additional municipal judge to a newly created department of the municipal court, the successor to that municipal judge must be elected for an initial term of not more than 6 years. 4.005 subsection 3 goes on to state that the city council has discretion over the term of that newly elected judge so that as nearly as practicable, 1/3 of the number of municipal judges be elected every 2 years. So that's where they get the staggering of elections, because they have control over the term of the elected judge, not more the term of the appointed judge. Okay, then I will just continue. Most of it's in my pleadings, Your Honor. I know that the court has read them. So I guess I will not continue with my argument unless the court has specific questions.
No. If we want to get specifically to, what are you looking to do here? Because one of the arguments that the city proposes is, look, we did this a year ago. Why are you now coming up with this? It's untimely. We've got elections starting just in a few weeks.
So, Your Honor, they completely skipped the 2024 election cycle, which they've appointed till 2026, but there's another election cycle happening in 2024, which they've completely glossed over and said, oh no, we're just appointing for 6 years here.
So, what are you actually
So
looking
we would
for?
prefer that the court would order that they have to put Department 1 on the ballot for the 2020 election, 2022, sorry, election cycle. Because the appointment cannot extend, under the terms of the charter, the appointment cannot extend past this election. So that causes a real problem with a judge who doesn't have the authority to act at that point
I guess I could reappoint him.
in the department. I suppose.
Because I'm just trying to figure out what you're looking for here.
So we're looking for
Because the election is the filing period starts in March. They're arguing they're prejudiced.
So we would argue that they're not prejudiced because they people haven't even filed to be on the ballot yet. So the candidates haven't even had a chance to even declare candidacy. Now they were talking about filing paperwork with the Secretary of State. They have control of it. We can delay we can delay the candidacy period, perhaps, something like that. But really, what we really would like is for the court to order that that Department 1 be placed on the ballot for this upcoming election.
And so the authority of this court to tell the city of North Las Vegas to do that is the ordinance that they passed is a violation of
Their city charter.
Of the city charter. And what about Nevada election law and Chapter 1 of the Nevada Revised Statutes,
They're
which
required to
govern
work within
the
the framework
judicial
of their
departments of the state of Nevada? Pardon?
I said they're required to work with the framework of their charter, so they would have to have the election.
Okay. And so this court has jurisdiction to tell them they violated their own charter, and they must. Yeah, because you specifically filed a writ. So what are you looking for with the relief that you're seeking?
I would ordering them to put Department 1 on the ballot for 2022.
Okay. Okay. And if their argument is that this is prejudicial to the city because we've already started, set up our election for 2022, and this department's not on any of our election documents, you'd have to start all over again. Even though the candidates haven't filed for it, they still have the offices that are on their ballot identified. So
I would think they could be amended, but if for some reason they couldn't be amended, then our second hope would be that they would be forced to hold the election in 2024.
Okay. All right. Great. Thank you. Good to see you.
Thank you, Your Honor. Pat Lundvall on behalf of the city of North Las Vegas. And what I'm going to do is to divide my remarks into 4 parts. And I'm going to address particularly the issue that the court raised as to whether or not that this is a new department or if it's a vacant department. And for that, the court needs to have a little understanding as to the factual background because of the factual issue that was raised for the first time in the reply brief. And this is the first time then that the city has had the opportunity to address this factual issue. That factual background also informs then the application of the laches defense, and it also begs the question as to whether or not that all necessary parties are before the court for the relief that is being sought. And by that I mean Judge Lee has not been named as a party, and he has an interest then in what the outcome then of this litigation is. The second part of my presentation this morning is that trying to give you a framework for your standard of review, because there was no framework that was offered by the ACLU, and I think it's important for this court's analysis to have a proper standard of review. Then what we're going to do is to go through and apply then the standards to the city charter as well as to the state statutes to demonstrate that there's nothing wrong with the ordinance that they have challenged. And last, we're going to walk through the factual presentation on the latches doctrine and demonstrate the prejudice not only to the city and the change in position by the city, but also the change in position then by Judge Lee, and also the change in the position by any potential candidates that may have had an interest, but now are going to be foreclosed because of the very election laws that you identified. I suppose that there was a label that we could put on this case, and once you, after the court learns a little bit of the factual background behind the creation of this new department, I think that label would be no good deed goes unpunished.
But that's not what it's about. Nobody is disputing that Judge Lee is a fine judge. Nobody is disputing that the concept of the care court is a great concept and it benefits the citizens of the city of North Las Vegas. Nevada law has always provided for an elected judiciary. Every effort to do away with an elected judiciary has been struck down by the electors. The argument is you're violating Nevada public policy and law in appointing a judge for a period of 6 years. Nothing in Nevada law provides for that kind of an appointment. We have an elected judiciary. The electors have the right to vote. That's the problem.
Well, and that's where it looks like I've got my work cut out for me.
Yeah, you do.
I understand that.
Does this person deserve to die? I think the question needs to be rephrased, right? The true question that we need to ask, though, is do we deserve to kill them?
And there's been about 200 death sentences handed down, 189 actually, about 155, 160 people. The reason for the difference, some people get multiple death sentences. Patrick McKenna was sentenced 4 times to death, overturned 3 times.
This also ties into something else that we're dealing with here, which is a drug added to the drug cocktail solely for the purpose of making an execution look clean when it's not. That if something goes wrong, the general public won't know what's happening. And so it raises a question.
For those that don't know me, which should be difficult in Nevada, my name is Judge Cheryl Moss. I served in Family Court, Department I, and
For the record, I don't say these things to hear myself talk.
An absolute decree of divorce is granted.
By September 6th, you will pay $6,000 of what is due.
In the dependency arena, you really do boil down what the best interest of the child actually means. You could have a party argument.
Ask the question, make sure we're being accurate with what the document states.
And I said, you know, Grandma, I'm going to be a legal secretary just like you. And she looked at me straight in the eye and said, no, you're going to be a lawyer.
One of the issues that the court system has is
But with all due respect, when I walk the court then through the analysis,
Okay.
I think that you can understand this position where we're coming from.
All right.
But let me address, though, one thing, though, for you very first and up front. The city of North Los, the ACLU raised a factual issue before you for the very first time in their reply brief. And that factual issue then demonstrates that you can't and you're not empowered to grant a writ.
Mm-hmm.
That factual issue then requires factual determinations. And under the statutory framework for the issuance of a writ of mandate, then there's a very definite structure by which that factual dispute is supposed to be resolved. Now, we don't think that there's a factual dispute, but they have raised it. And they have argued then that this is an existing department. The court seems to have embraced their argument that this is an existing department, but there is a factual dispute on that based upon the documents that they have given to the court.
Well, I went to Judicial College with the judge who held Department 1, Judge Ramsey.
Judge Ramsey's department, to which that she was originally appointed and
she was elected
and ultimately elected, was abandoned, was shut down by ordinance number 2786. There is a specific ordinance that shut down that department. And when that department that was shut down left a single department in the city of North Las Vegas, Judge Holgren continued to use simply the label of Department 2, but there is a very specific ordinance that says, based upon the lack of case load in that department, and based upon the financial constraints that the city was facing, we are abandoning that department. So that department no longer existed. There was a single department for the city of North Las Vegas. As of the beginning then, toward the end of the ordinance that abandoned that department is dated in 2016. And so from 2016 then to 2021, there was a single department. And the city then identified a problem and an issue based upon the opening then of the new Community Correction Center that opened in June of 2020. And let me, as far as try to see if I can't put into context then the problem that the city has identified. The city of North Las Vegas, as the court may well know, is about 250,000 residents. It has the highest percentage of individuals living under the poverty rate of any city or any municipality in our state. And therefore, when COVID hit, they were one of the hardest hit by the unemployment that was caused, and unemployment then causes significant community issues. When the Community Correction Center opened in June of 2020, the statistics then demonstrated that the recidivism was largely coming from certain populations, and the problems that those populations were presenting with were not being identified, were not being addressed, and that those populations, in large part, addressed a veterans population, for which that the city of North Las Vegas has one of the highest percentage of veterans living within that municipality. And that's no surprise because the VA hospital is out there, Nellis Air Force Base is out there, so veterans have access then to, commissary and basic privileges, and also the Fisher House is located in North Las Vegas. And so the city, when it identified that it had a problem, it studied and came up with a solution. And that solution then was to create a diversionary court that would address them and identify those that may be eligible for participation within that diversionary court. And what it did then is that it wanted to have someone who was familiar and that could quarterback the interdisciplinary approach that they wanted to bring so that they could address then the recidivism among the population that was specific and unique then to the city of North Las Vegas. Now, one thing that I think is critically important to understand is that the quarterback for this program was going to be, and was specifically designated to be, the municipal judge who filled the new department that they created to be able to accomplish then what ultimately they called the care court, but it was the diversionary court then, so that these individuals could be identified, and if in fact that they qualified, they could be taken out of the criminal justice system temporarily. They could have their problems addressed, and if their problems were addressed, the idea was that maybe the recidivism then would go down. And the results of this court and the work that Judge Lee is doing is tremendous. That quarterback was critically important to be able to establish all of this interdisciplinary approach. That quarterback had to work not only in creating new court staff, because there was no court staff then for this new department that was created by the city, because all of that court staff then, I don't want to say had been abandoned, but when the department was shut down in 2016, there was no court staff then in that particular department. In addition, they had to coordinate with law enforcement. They had to coordinate them with the city attorney's criminal division. They had to coordinate then with the therapeutic partners that the city had contracted with and had organized with, and also with community corrections staff, center staff. And so the quarterback then, who was going to fill this department, was going to be critical to the success then of this department with this court, and whether or not that this court then was going to be successful in accomplishing then its particular task. All of this was set out in the ordinance that has been challenged by the ACLU. And now in particular, what they have suggested in their reply brief for the first time is that somehow that this department already existed. And this department then falls under a different analysis than what they had originally presented in their written petition. We disagree. And that's a factual dispute. And that factual dispute then takes this out of really the court's hands to be able to issue the writ of mandate that they're asking for you to issue today. And the true facts that would come out then through either an evidentiary hearing, through a bench trial, or as the statute provides, through a jury trial to be able to resolve that. But what those true facts reveal is that Department 1 was dissolved in 2016. That dissolution then was found under Ordinance 2786. And in the new ordinance 3060 that's at issue under this petition, that's when they renumbered then the department so as to allow then Judge Hoffman, who continued to use the label of Municipal Court Judge in Department 2, he could continue to be Department 2, but Department 1 was the new judicial department that was being created. And that department...
If they really wanted a new department, couldn't they just call it 3?
They could have, but then they would have ended up with Department 2 and Department 3.
Yeah.
And so...
But 3 would be new.
And 1 was new as well.
Okay.
The question, what the court is, I guess, I would beg this question.
It does beg a question.
Is whether or not that somehow, and there's been no challenge by the ACLU, is if the city has the power to put the numbers on the departments that it creates. There's no challenge that's been made to that. There's been no issue that has been made to whether or not that we called it Department 1 or we called it Department 21. It doesn't make any difference what label we put on it. What matters is the substance of that department. And the substance of that department is that it was being created from whole cloth. And that whole cloth was to be able to create this diversionary court. That whole cloth then is what was designed and offered as a solution to the very specific local problem, the matter of local concern then, that the city was facing at that particular point in time. And so the substance then of that department No different as far as then the label was fully empowered by the city to create then this new judicial department. So if we go back then to the chronology then, because I do think that the chronology is important, particularly to the latches defense, Your Honor. And that is that the ordinance creating this new department, and it was describing it as a new department, and describing the reasons why it was being created, and the purposes and the importance of having a quarterback then so that it could get off the ground, it could have a fighting chance to be able to accomplish the solutions that it wished to achieve. It was originally proposed in January of 2021. On January 6th, it was discussed again on January 20th of 2021. It was discussed again on February 3rd of 2021. It was February 17th, 2021 that formally then, that the ordinance was passed and Judge Lee then was appointed. As the court indicated over a year ago that an appointment was made. That ordinance also identified the label that was going to be put on this new department, and it also identified then the length of the term to accomplish then the staggering of the elections, because that's the one thing that the ACLU entirely ignores. Hasn't touched one bit when it comes to the staggering of the election. Now, also, in continuing on as far as with the chronology, prior to the specific appointment then by Judge Lee, the opportunity then to apply for this appointment was open and notorious. They identified as far as the type of credentials that they were looking for. They identified and told the candidates who were seeking that appointment the length of the appointment that would be made and the city ordinance under which it would be made. After the new department was created, after Judge Lee was appointed to that particular position, and after a vetting then of the different candidates that had applied, that's when Judge Lee gave up his private practice. He changed his position in reliance then on this ordinance in the length of time that his appointment was going to be, and gave up his private practice. In addition, the city changed its position. The city then put resources then toward this new department. It put resources toward this new program. It put resources then to trying to ensure that the solution that they were hoping to accomplish was going to stand a fighting chance. And in addition, they applied for a grant from the Department of Justice. And in that grant, which was all a matter of public knowledge, is that they identified the length of time of this appointment, not only as far as with the method by which the appointment accomplished.
I was a little confused about the grant, because the grant specifically referenced Judge Lee as being the person who was going to take this appointment. So when the grant was applied for, did they already know that, or did they?
The grant was applied for after the ordinance was passed, after Judge Lee had been appointed to the position, and after he had already taken.
So they'd already filled this position, and then they applied for the grant.
Yes, Your Honor.
The grant was not dependent on who they were appointed.
That's correct, Your Honor.
I get it. Okay.
Well, no, the grant included recitation as to who was appointed because it identified the background.
Right, but the plan was, and that's why they allegedly created this new department, was as part of a strategic plan they had to create a concept of creating this treatment court and specifically hiring somebody as a judge to, which, you know, I'm not sure the judge does that much, but anyway, judges are kind of limited in what they can do. So they had a plan that they would have a judge, and so they had a framework already, and all that they were waiting was to slot in a name and submit that for the grant.
No. The grant opportunity came after the creation then of the department. Mm-hmm. The grant opportunity was applied for after the creation of the department, and the grant opportunity came after then the appointment of Judge Lee. The grant included reference then to having someone who would have background and experience and who would have the time by which to get this court up and running with using that background and experience. And the one thing that I think is important is that that grant application came with a letter of recommendation from the Office of the Courts from the Supreme Court of Nevada. That letter that was a part of the grant application made express reference to the ordinance and how that the Office of the Courts for the Supreme Court of Nevada supported then that grant application. So there is some tacit approval then coming from the Office of the Courts from the Nevada Supreme Court.
From the AOC.
I'm sorry?
From the AOC? Not from the Supreme Court, but from the AOC, the Administrative Office.
AOC, yes, right. And then thereafter, the city then ratified the application process, and it accepted a grant then of over $500,000 then from the DOJ, and that was in June 2nd of 2021. All of these actions, all of these activities, they were open, they were notorious, they were a matter of public record, and there was no question, no one had questioned or had challenged this. Now that the challenge has been made by the ACLU, I think that the court, it's important for the court to look at then the chapter under which that they seek their writ relief. That's chapter 34 then of NRS. Chapter 34 invests authority under NRS 34-160 for this court then to issue a writ of mandamus, but only if the facts are undisputed. You go down into NRS 34.260, if there is a factual dispute upon which that the court's authority is being exercised, then in fact that the court does not have the authority under this type of a process by which to issue a writ of mandamus. There must be then resolution of that factual dispute, and that factual dispute then requires then either an evidentiary hearing or by the party requested a trial by jury. And the Nevada Supreme Court has endorsed the reading that I have given to the court of that particular statute in Goldman versus Bryan, that's found at 106 Nevada, 30, 787 Pacific 2nd, 372. It's a 1990 case. And so why am I telling the court this now? Because they only raised this factual issue for the first time in their reply brief. So this is our first opportunity then to try to underscore with the court that the power in the request that the ACLU is making of you today cannot be done because of the factual dispute that they have raised.
Well, did they raise it though? Because it seems that the city raised it by arguing in their answer that this was an appointment to a, quote, new department.
Understood. And the chapter NRS 34.260 addresses that issue too. If either our answer addressed a factual dispute or raised a factual issue, or their petition in reply raises a factual issue, then in fact it still takes the power away from the court under this type of a proceeding then by which to issue a writ. And think about this. This makes sense. In the petition that was filed by the ACLU, they have literally no factual background whatsoever. They have no factual recitation whatsoever. It was our answer then to give the factual context not only as far as for the creation of this new department, but also the application of the Laches doctrine. And they were, I guess, addressing that particular issue, trying to quarrel and quibble and to suggest that no, they didn't create a new department, that it was an existing department and therefore a different provision of the city charter then applies. That was their argument in their reply. And so to the extent that I'm not trying to be obstructive with the court when I bring this to the court's attention, but I'm trying to, as far as to ensure that we're not creating some type of legal error, then that we need to, as far as ask a higher court then by which to address. The other thing that too is that the ACLU did not give to the court, and that is the appropriate presumption that applies as to if it had the power to do what it did and the appropriateness of that power. And what they suggest to the court is actually a thorough misapplication of Dillon's rule and the power of municipalities to do what they do. And to be candid, I'm going to, as far as give them a little bit of leeway, because I don't think it's an easy issue to understand. Why do I not think it's an easy issue to understand? It is the last case that I argued to the Nevada Supreme Court. It dealt with the opioid cases and whether or not the municipalities and counties had power by which to bring the various opioid cases. And the Nevada Supreme Court issued a decision based upon Dillon's rule. And that decision then underscored the interpretation that I am bringing to the court that we set forth as far as in our answer. And that being this: the city is a municipality. It was created by statute then from the legislature. Dillon's rule, which is a rule that speaks to what powers that a sub-government or a sub-entity of the legislature may exercise. Dillon's rule said, the old portion of Dillon's rule basically said, unless if there was an express power that was set forth within the statute, then, in fact, it was presumed that the city did not have the power to do what it wanted to do. In 2015, the legislature changed Dillon's rule, and it changed the way Nevada is going to apply Dillon's rule. What the Nevada legislature did in 2015 into the statute that is found in Chapter 268 of NRS is it said this: if there is an express or implied power that the legislature has given to the municipality, or if the municipality is addressing a matter of local concern, and a matter of local concern is very specifically defined in Chapter 268. If either one of those occurred, there was a strong presumption that in fact that the power that was exercised by the municipality was actually held by the municipality and was appropriately exercised. And the only way that that can be overcome is by a challenger like the ACLU that brings to this court then strong evidence that the legislature has acted and said that we can't do what it is that we did. And in fact, that's not accurate. What we have done is we've brought to this court's attention the express statutes that not only create the power, but said that we had the power to do what it was that we wanted to do via ordinance. And so let me walk you through that analysis. Not only did we bring to the court's attention the express power that was set forth in the city's charter. And the city's charter, for lack of a better word, is like a constitution. But that charter, though, has been stamped as approval then by the legislature, so it has a legislative imprimatur that is applied to that. And so it's as if this legislature is speaking as to the power then that it has granted or delegated to the municipality. And in the interest of time, what I want to do is to direct the court's attention then to footnote 10 of our brief. In footnote 10 of our brief, we identified the three-part test that underscores and meets then the definition of what is a matter of local concern. Because that's candidly where one of your colleagues, the district court judge, got a bit confused, is that a matter of local concern sounds like that there's some kind of a common definition for that. Not so. The legislature specifically defined what was a matter of local concern. It's a lengthy three-part analysis. We set forth that lengthy three-part analysis, how we fit that, and there's been no challenge then by the ACLU. So the framework that we have going into this hearing is that they were obligated to come to this court with strong legislative statements that said that we were not empowered to do what we did. And so from that perspective, Your Honor, what I'm going to do is to walk through then that how that there is no legislative intent to the contrary of what we did, but in fact there's legislative intent that says we were allowed to do what it is that we did. So let's start with this. If you look at our city charter, at section 4.005 subsection 1, it looks at the ability then for the city by which to not only establish a new department, to appoint a judge to that new department, but also to establish the term of the new judge to that new department. It identified with specificity that 4.005 subsection 1 was subject to chapter 5 and chapter 266 of the Nevada Revised Statute. So, in our supplemental brief that we brought to the court's attention, to which the ACLU responded, we identified that under NRS 5.020, it says that the term of office of a municipal judge is a period fixed by one of two things, either an ordinance adopted by the city, if it's under general law, or the city, if it's the charter of the city, if it's under a special charter. So if you look at that and apply then 363060, what you'll see then is you can look either to our city charter and also our city charter under section
4.0054, except as otherwise provided by the ordinance establishing an additional department, each municipal judge must be voted upon by the registered voters of the city at large, and except as otherwise provided in sections 5010 and 5100, holds office for a period of 6 years and until his or her successor has been elected or qualified. That's what the city's relying on, that gives them the authority to deviate from the elections section, which is 5.010, talking about how when you appoint somebody to fill a vacancy, then you have to be confirmed by the electors. So you're deviating from the public policy of the city of North Las Vegas, as stated both in their charter and in the statute, because of this public interest.
No, Your Honor, that's not our analysis.
Okay, fine. Okay, I get it. Fine. We can move on.
My apologies, and I'm just trying to be informative to the court, all right? So to the extent
we need to move on. So yeah. So what's next?
All right. Our charter under its original and under section 1. Section 1, I think it's .010, has a special section that says that we are able to do anything that is empowered under the general laws of the state of Nevada. The general laws of the state of Nevada says that we are empowered to set the term then for a new department, and we are able to set the term then of a judge for appointment to that new department. And that's found in section NRS 5.020. And so to the extent that also...
So 5.030, applicability of state election laws and over city, under city council control. Provisions of 293, 5772, 293, 5887 inclusive supersede and preempt any conflicting provisions of the charter. Nevada election laws, I said at the beginning, they've tried to change Nevada law so that we have an appointed judiciary, and it's been soundly rejected every single time. So how do we overcome the Nevada election law that provides that judges are elected, and that if you appoint a judge, that judge has to then stand for election? It's like...
The next step in my analysis then is NRS 266.405, subsection 1.
Okay.
That's what we brought to the court's attention then in our supplemental answer to their petition. It identifies that a municipal judge, that's what's at issue here, is a municipal judge, may either be elective or appointive offices as provided by city ordinance. So to the extent that we have given the court the legislative intent that empowered us to create 3060. Not when you couple section...
So the city intends that this new Department 1 is always going to be appointed? It's not going to be an elected job?
No, because then it's different. After that appointment ends, then a different section of the charter kicks in.
Okay.
That different section of the charter kicks in because of the fact that it is now going to have a vacancy. When in fact, well, this is where, as far as this, what we're trying to do is to address then the fallacy of the ACLU's position, is because the section that they identified, and let's start with where I candidly, I think that where they go wrong. Under section 1.060 of the general provisions of our city charter, it deals with the elective process when there's a vacancy in any of those offices. There is no vacancy in Department 1 until expiration of the term that was set by ordinance for Department 1 that now Judge Lee fills. When Judge Lee's term comes to an end, there will be a vacancy created for that. And that's where section 1.060 comes into play. The next one that they cite to the court as trying to be supportive of their position is section 4.005, subsection 3. But when you read 4.005, subsection 3, that one deals with the successor to the appointed position. So the successor to the appointed position must go through the elective process, but not the appointed to the new department. Also, when they rely upon section 4.005, subsection 4, but what they do is that they ignore the qualifying language that is in there that specifies, and I'm going to quote this, except as otherwise provided by the ordinance establishing an additional department. They completely ignore that. That particular language under subsection 4.005, subsection 4, is the one whereby our ordinance not only identified the new department, that there was going to be a judge appointed to that new department, but also what the term of that new department was going to be. At the expiration of that term is when there will be a vacancy, and therefore section 1.006 kicks in. There will be a successor at that point, and that's where section 4.0053 kicks in. But it is only upon expiration of that term for which there will either be a vacancy or a successor to that appointment. And that is nothing but a simple or a plain reading then of the charter.
Okay, so your position is that even if this court says, well, this is a new department, the city had the right to do so, to create a new department and to say that it's got a 6-year term, their authority for that, as opposed to saying, we're creating a new department, here's our appointed person, and they will stand for election at the next possible election, which is what typically that happens and what the charter otherwise provides for. But they have the right to do so in this special way, and they could have done this for anything. They could have said, we're going to create a new city council person, and that city council person is going to have a position for 8 years, because we decide they're going to.
With all due respect, well, I haven't looked specifically at that, but I have looked specifically as if the municipal judge can be either elected or appointed, and whether or not a municipal judge can be, the term for the municipal judge may be set by the city council.
Okay.
And that's where we brought the state statutes to your court's attention, both under Chapter 5 as well as under Chapter 266. Both of those state statutes deal with the fact that via ordinance we were empowered to do what we did. And so to the extent that there's been no touch as far as on either one of those issues or no analysis then by the ACLU. And so when you take a look then at what their position is it first and foremost, even if there were no factual dispute, and even if they try to concede today, okay, we're abandoning this new issue that we raised in our reply brief, that if in fact that they acknowledge that this is a new or an existing department, their interpretation of the city charter not only runs contrary to the plain language of the city charter, it runs contrary to the plain language of our state statutes. It also ignores the city charter then as a whole, and that it creates surplus language in other sections that speak to express by, except by express ordinance of the city council. It takes language from certain portions of our charter and puts it in the trash can and entirely ignores that. That section in particular is the chapter, the section 4.005 subsection 4. It takes that language and says, trash it. That doesn't apply. Well, common statutory interpretation language does not permit that to happen. There also, their interpretation also contradicts other important provisions found within our city charter.
Okay, so with respect to the question of fact and the fact that you believe this raises a question that there are dispensable parties who are not in this litigation, specifically Judge Lee, who has an interest in this appointed position that he was appointed to, the ACLU argues that appointment was in violation of Nevada law and the city charter because it was for a period of 6 years, didn't require that he do what every other judge has to do, which is stand for election at the next available election. So what? So your position is that we should have a jury trial and Judge Lee should be made a party?
Well, what I'm saying is that they continue with the position for which they think that there's a factual dispute. And also that they ignore that the latches doctrine that we have sought to apply. Then in fact, the answer to that is yes. And they also have to make Judge Lee then a party to this litigation. And so, and the other thing too that they entirely ignore is while they claim that the court could be empowered to say, well, since the filing period for judicial positions has not yet expired, what they've ignored is the fact that the Clark County has already solicited from the city what positions are available to be filled for which a candidate may file for. Those time frames have already gone. So a candidate may throw his hat in the ring, but unless there is something, a ring for them to throw their hat into, that filing period means nothing.
Okay, so what? So your position is the writ should be denied. The court should set a schedule by which they bring in these dispensable, not indispensable parties. Is that just Judge Lee, or is it also the county election department? Who do you believe they've left out of the case?
Well, your point's a good one. At minimum, I think it's Judge Lee. Judge Lee is the person that most particularly, as a candidate, he looked at the offering that was made available to him, and that offering said there is a position, that position, the term of that position is going to be a 6-year term. He relied upon that offering, and he put his application in. The city accepted his application, no different than others put in applications as well. And when he was selected to that position, then he gave up his private practice. And that was all over a year ago. And now the ACLU, with no explanation whatsoever as to why it is that they've waited a year to bring this writ petition, they entirely are silent on that particular point.
So is latches like an absolute defense to this writ, or what's your argument with respect to latches?
Latches is an absolute defense to the writ, and we brought to the court's attention in the case law that speaks to the fact that latches is an absolute defense. And equally, what you're looking at, and I think the court raises a good point, as to whether or not that there are, like the Clark County Elections Department, if they too need to be made a party to this because of the procedures by which that they employ when they solicit then from the municipalities, the counties, and the state as to what offices that are open to be filled for them to make announcements then for candidates that throw their hat in the ring.
All right, thanks.
But one last point, Your Honor, because I haven't addressed this, and I just want to touch on this, and that is this. Another portion of our city charter speaks to staggered elections. And the interpretation that has been afforded by the ACLU or been offered to the court violates then that staggered election requirement. Because what they do is they put both departments then up for election in 2022. And they put both departments then in violation. They put that staggered election requirement then, and they take that and they just ignore it and once again put that in the trash. And when an interpretation that is offered by a party, whether it be of a city charter, whether it be of a statute, makes irrelevant or that they ignored or makes surplus that language, then that is the first indication that a judge is supposed to look at to say that their interpretation is not appropriate. And so that...
Well, but counsel also indicated was, well, if not 2022, then 2024. How does that affect that argument?
Well, from that perspective, it still then says that there was no power by which then to do via ordinance what both the legislature and our city charter says that we were empowered to do. And they have brought no contrary authority to the court's attention.
Right,
and if the
thanks.
court looks at one last case site I think is a worthwhile review, is the Halverson versus Secretary of State case. The court may recall when Judge Halverson tried to challenge that as to whether or not that there was the power then by which to set appointments. The Nevada Supreme Court then went through that full analysis and identified the power then of the legislative entity to set appointments and to be able to accomplish the goal of staggering all the elections. She challenged as to whether or not it was appropriate then for her to be only appointed to a 2-year term versus a 6-year term. And in fact, the Nevada Supreme Court beat that back and said no, that the legislature was empowered by which to do it. The same analysis that the Nevada Supreme Court employed in Halverson also applies in support then of the importance of staggering the elections then by the municipal charter and that was employed.
Okay, thanks.
Thank you, Your Honor.
All right, thank you. Let's move on.
Okay, I'm going to try to respond to as much of that as possible. So, Your Honor, under NRS Chapter 34, with the writ, with regards to the writ and the court's authority with the writ, the only time a jury trial is required is when the answering party raises issues of relevant facts. It's not relevant here whether the department is new or old. Whether it's a new department, whether it's an old department, it's this charter, section 1.060, subsection 2, and also the charter at section 4.005, subsection 3, requires that after an appointment, they hold an election at the earliest election. It's 2 places in the charter, under appointments, under 1.060, and also under municipal court, new departments, under 4.005, subsection 3. So, okay, so 1.060 says, no such appointment extends beyond the first day of the month following the next general municipal election at which election office must be filled for the remaining unexpired term. 4.005 subsection 3 says, at the first primary election or general municipal election that follows the appointment of an additional municipal judge to a newly created department of municipal court, the successor to that municipal judge must be elected for an initial term of not more than 6 years. We're talking about elections after appointments. The charter requires it. The status of the department, why I agree factually that it's not a new department, is basically irrelevant, because either way you want to cut it, they have to hold an election.
And so the issue isn't, because it's an ordinance, and so the question is, the charter is the charter. They have an ordinance. The question is, does the ordinance violate their charter? And so that's really the question. It's they have the authority to pass whatever ordinance they want. The ordinance, however, must comply with the charter. And in this case, the argument is it just doesn't comply with the charter.
Exactly, Your Honor. And the charter itself talks about NRS Chapter 5 and NRS Chapter 266, but it says, to the extent it's not inconsistent with the charter. In other words, the charter governs. Just like Ms. Lundvall said, the charter is the constitution here of the city. The charter specifically says NRS Chapter 5 or NRS 2.66, and that says, to the extent not inconsistent with the charter. So let's see. As far as staggered terms, Your Honor, both in our reply and in our the first couple minutes of my oral argument, we recognize that staggered terms are addressed because the city has control over the term of the successor judge, the newly elected judge, because they are elected for a period of not more than 6 years. So that is where the city gets the authority to have staggered elections, is because after the appointment, at the first election, when the new judge is elected, it says that they will hold a term, must be elected for initial term of not more than 6 years, as determined by the city council, in order that, as nearly as practicable, 1/3 of the number of municipal judges be elected every 2 years. Subsection 4 of the Municipal 4.005, when they're talking about a period of 6 years, they're talking about an elected judge. So each municipal judge must be voted upon by the registered voters of the city at large, and except as otherwise provided in sections 5.010 and 5.100, holds office for a period of 6 years and until his successor has been elected or qualified. So
what they do is you appoint a judge for a certain period of time. At the next election, they stand for whatever period is designated. If in order to comply with the staggering of the terms, it needs to be 6 years, it's 6 years. If it needs to be 2 years, it's 2 years. If it needs to be 4 years, it's 4 years. For example, Judge Bulla ran to retain her seat on the Court of Appeals. She's got to run again for her own new 6-year term.
She was appointed in 2019.
Because she was appointed.
She ran in 2020. Even the Court of Appeals, Your Honor, they were all appointed in 2014. They all ran for election in 2016. All 3 judges stood for election at the same time. As far as naming Judge Lee as a party, Judge Lee didn't do anything wrong here. Judge Lee didn't create the ordinance. Judge Lee did not...
Does he have a property interest in the office that he holds?
Your Honor, if he has an issue, if he has anything that's actionable, it's against the city. It's against the fact that he justifiably relied on the city telling him he was going to have a 6-year appointment, when in fact the city did not have the authority to issue him a 6-year appointment. So he has a cause of action. It's against the city, Your Honor.
So, but he's not a necessary party
He is not a
in this case.
party.
And there's no need to have a jury trial because
There's no need to have
this is a
jury
pure
trial.
question of
There's
law.
no factual dispute that is relevant to the reading of the charter.
Right? And what about latches? Because that's their other argument is that you had 10 months to do this. The city has already told the county what to put on the ballot. The ballots are already set up for the elections to be held starting filing period to start in March. Everything's been printed.
Your Honor, it's an invalid appointment. I would think that they would be able to amend that. Again, also, I know that they were talking about Dillon's rule and the fact that they applied for this grant with respect to Dillon's rule. Again, Your Honor, Dillon's rule, the legislative intent here is clear through the language of the charter. They have to hold an election. They cannot appoint a judge for 6 years. They must, if they are filling a vacancy or they're creating a new department or however you want to call it, under the terms of the charter, they are required to hold an election at the next possible election. They're not allowed, under any rule, to work outside the framework of their charter. The ancillary statutes that they cited are just not applicable in this matter. The staggered terms I've already addressed. As far as latches goes, we don't see that it was 10 months from the time Judge Lee got appointed to the time we filed the petition. Latches has a very high standard. There is no statute of limitations here that has passed. We're not looking outside of the statute of limitations. We did this as soon as apparently that it was brought to the ACLU's attention. We don't just file suits for fun. People have to bring matters to our attention. And they haven't shown any actual prejudice other than the ballots have been printed, which can be, or not ballots have been printed, but paperwork has been sent to Secretary of State, which hopefully can be amended.
Right. Thank you very much. Right. I'm going to grant this writ. This appears to me to be an ordinance that is clearly in violation of its charter. As I stated at the very beginning, Nevada has a long-standing policy of an elected judiciary. Whether this is a new department or an old department, it really, as counsel said, it's in the end doesn't really matter because the charter itself provides that anybody who is appointed is going to stand at the very next election. They didn't amend the charter. This was simply an ordinance passed saying this is the term. The ordinance can be in violation of the charter. I believe that it is. You cannot change the charter. That's the underlying governing document for the city of North Las Vegas, which took into consideration that their electors should have the chance to, at the soonest opportunity, have an opportunity to weigh in on anybody who holds an appointed office. This is an appointed position. It's got nothing to do with the merits of what's behind this care court. It's got nothing to do with the quality of the judge who is selected to run this program and the value it has to the community. All that is a given. It doesn't mean that somebody else couldn't take the position and do just as good of a job. It doesn't mean that this court would be incredibly disrupted in a change. It's not going to violate the purpose behind the application for the grant. While Judge Lee has unique skills and has done a spectacular job, it's not about that. With all due respect, it's nothing personal. That's why, as counsel said, this isn't about Judge Lee. He is not a necessary party here. This has got nothing to do with him. He has qualifications and skills, which hopefully the city electors will recognize and keep him in that position, as he has every right to file for it when everybody else does. On March, 8th, I think is the day that they start, whatever date it is, that election, 7th, I think it starts on the 7th, the first Monday in March. So yes, this gives us 4 weeks, and it is a challenge and a change to what's the county and the city have prepared with respect to the election documents, but it happens every election cycle. So they are prepared to deal with it, and they can. So I'm going to grant the writ. I believe that the ordinance is a clear violation of the charter. As you said, it's got nothing to do with the purpose for which this department was, what do you want to call it, reestablished, reopened, created, doesn't matter. The voters have the right to comment as soon as possible on appointments by the city government. That's the charter. This ordinance violates that charter, and that's the primary purpose of the city and the legislature that has endorsed it, is our electors will have that opportunity. It's not unique to judges. It's every appointment. Judges demonstrate it all the time. Nobody gets a pass on this. You stand at the next available election once you're appointed. So the term that you're appointed for is entirely different. The ordinance could be amended to state that on whatever the next election day is, we're going to have somebody run for a 4-year term. That's perfectly fine. I did that. I ran for a 4-year term to get on the same cycle as everybody else. That's where you make the adjustment to get the staggered terms, is in how long the term is. But you still have to give them the right to the electors the right when there's an appointment to comment immediately upon it by their vote. And this is a clear violation of the charter. It's in no way any kind of a comment on the purpose behind what the city was doing. It's a noble purpose. I hope they're having huge success, but it doesn't really impact this decision. I don't believe that there has been so much time. If we were well past the filing period, I might have a different view, but we aren't. And I don't believe we have to look to 2024 for this. I think it can be on the very next available ballot. As indicated, it's simply a question of how long the term is. That's how the charter reads, and that's what I think the appropriate approach is. So I'm going to grant the writ. I'm going to ask Ms. Romero to prepare the findings of fact that would support that and conclusions of law, and show that please to Ms. Lundvall. And good luck, everybody. See you at the ballot box.
2 points of clarification, if I
Yes.
could, please.
Yes.
I understand you want Ms. Romero then to draft the written order.
Correct.
And it's the written order then that controls as far as then the court's determination in here today. And what we are going to do is to look at and to reserve our right and to seek a stay of enforcement, not only before this court, but ultimately before the Nevada Supreme Court. And
That's why I hope that we can do this as soon as possible. So, Ms. Romero, how much time? Can you do that in the next week?
I can get you a draft this afternoon, probably.
Oh, okay. So, to Ms. Lundvall.
Oh, yes, I'm sorry.
And Ms. Lundvall has the right then to comment.
I will definitely circulate.
So, if with the way that we now do orders, the challenge is when we have competing orders, we can deal with it that way. But the old-fashioned way where we used to like sit 2 orders down on the table and compare them, we can't do that anymore because we get them electronically. So how do you want to, if you have any questions or comments about the order, how do you want to address that with a letter to chambers? How would you be proposing you would deal with any concerns you have about the order as drafted by Ms. Romero? Because I'm not assuming that you're going to sign off on her first draft. So.
Well, first and foremost, I'm going to try to work it out.
Yeah. I appreciate your willingness to do so. Thank you.
Before we would bring any dispute to the court's attention.
Yeah.
But to the extent that there are disputes that arise from that kind of meet and confer opportunity,
right.
The court then gives us a chance then to be able to give a letter that addresses what our concerns may be, if there is any.
And because I understand and I assume that they have the right to seek relief. So I'm assuming you want to make sure it is all teed up properly.
And because this is not an administrative determination by the court, that's why I wanted to clarify that it's your written order that is what we control, and that's the time frames then that we may seek then by which to bring any motion to stay, and the enforcement then of the court's order then.
Understood.
By notice of entry then of that written order.
Correct.
Thank you, Your Honor.
Okay. So, counsel, appreciate your willingness to act so promptly on it, and I'm sure Ms. Lundvall will respond equally quickly. Thank you all very much. Thank you. All right, so we'll move on then to our 9:30 matters.